When you've got a complex commercial case, which is going to have difficult issues of proving financial damages, that's an example of a situation where you clearly will need an expert witness, but not every complex litigation requires an expert witness. It's important when you approach a case either as a plaintiff or a defendant, one of the first things you have to ask yourself is, do you really need an expert witness in this case? And it's not always clear you do. In a complex commercial case, your impulse is going to be to automatically assume you need an expert, but you should take a step back and think about it. And here's the question you should ask yourself. Will having an expert genuinely inform the jury and help them persuade it to, or find in your favor on the case? The answer is not always yes. In some cases, experts could be additive and not cumulative. I mean, you want to make sure that your case is one where it's good, the issue is sufficiently complex that it's really going to help the jury. If you've got a non-jury case, a bench trial, you may have to think about it a little bit more. Some judges may be less inclined to admit expert testimony in a case where there really is no cause for it. They're going to be more skeptical. You don't want an expert if you're in a case and the other side's position is in any sense weak or even borderline defective. Retaining an expert witness in a case where you've clearly got the better case may send the wrong message for settlement purposes. It may dignify your adversary's position, so you want to be careful not to do that. Also, there's a category of experts that I've seen people retain in cases that I think are less than useful, and that is the sort of lawyer expert witness. And that's the expert witness who is going to opine on, the legal standards that govern your case. This comes up a lot in malpractice cases. It's come up in cases I've had defending investment advisors where the standard of fiduciary duty is at issue. And in those types of cases where you have fiduciary duty issues, there's a temptation to have an expert lawyer witness to opine on whether the duty was satisfied, whether the duty was met, what the duty entails. Those are difficult experts to succeed in getting before a jury, because most courts will be inclined to view them as simply cumulative, restating the law, opining on conclusions of law, which are things that under the federal rules of evidence you can't do. So I would be strongly inclined not to use experts who are only going to be sort of repeating the role of the lawyer.